I think we can start. Let's invite the officials in. Please invite the officials in. Good afternoon, everyone. Let's confirm the minutes of the last meeting. Can we confirm the minutes then? Thank you. Three submissions have been received since the last meeting. One from the Law Society, one from the Bar Association, and one from the LAB, Labour Advisory Board. The Law Society hasn't given any new views. It merely repeats the views made in 2013. But as far as I can remember, the Law Society hasn't given any comments concerning appeals to the CFA. They support our proposal. And I believe you've already given written replies to the Bar Association and to the LAB, right? Yes. Members raised a number of issues last time. Do you wish to respond today? Concerning appeals to the CFA, I understand that the administration is still preparing a paper for us. Is that right? Is it that the paper has yet to be completed? Thank you, Chairman. Last time, members asked us to do some research concerning appeals. In fact, we've started collecting the information. And it's likely that we will complete the paper by the end of August. Subject to members' agreement, we can have a meeting in early September to discuss appeals to the CFA. Now, as you haven't finished the paper on appeals to the CFA, we will deal with the other issues first, and then we will come back to the CFA in September. And then anything else, Mr. Lee? Concerning or otherwise, we will respond next time after all the data are available. And then Cap 221, Criminal Procedure Ordinance, whether it needs to be amended to enhance the protection for victims of sexual offenses. We are of the view that it is not appropriate for us to include such amendments at this stage in the bill. So you bring the matter back to the AGLS panel for discussion, yes. So please give this remark to us in writing, and then we will bring the matter back to the AGLS panel, all right? So, if members do not have questions on the other issues, then we can start clause by clause scrutiny.
姓李㗎嘛。阿李生，咁麻煩你。
Mr. Lee, so can we start from page 1 of the marked up copy? Yes, that's 79A cap 221. And we want to replace a CCTV by audio-visual facilities.
According to the Bar Association's submission, they are worried that your amendment may affect the safety, may have an impact on safety. Paragraph 5 of the Bar Association's submission. And the Bar proposes that by means of subsidiary legislation, you can specify technology and the kind of safeguards that can be included. Have you considered this possibility? Indeed, Chairman. We're not inclined to specify the technological specifications in the subsidiary legislation. Now we have the Committee for Users of Criminal Court. We believe we can use administrative means to consult the committee and then put in place special arrangements. We believe that will be more flexible. And the committee has representatives of common users of our court, including Bar Association and Law Society. This will ensure that a new technology will be able to comply with the security requirements. Who's the chairman of the committee? Justice Thompson. There is the Judicial Registrar of High Court, the Chief Magistrate of District Courts, and also representatives from the Legal Aid Department and the police. The Bar has also got one representative there, and so does the Law Society. So you will propose that the committee be asked to address the Bar Association's concerns. Yes, we do have such a mechanism. For criminal procedures, well, if the users have any comments, they can reflect them to the committee. I think that is the right platform to address the Bar's concerns. I believe it will be an appropriate venue. Will the judiciary consider using a practice direction to tell the public the technological and also measures to technological measures and safeguards, please? Yes, that can be considered so that the public know how we deal with security issues. Mr. Tang, I'd like to ask about the operation of the Labor Tribunal. We are pleased that you have removed the palpable disclosure of documents in the Labor Tribunal. We had strong views about that, and we will just leave it because you have dropped it from your proposal. Now, after the Labor Tribunal has made a judgment, now instead of registration within 12 months, now it will be put on par with other civil court. The limit is now 6 years. Now, if an employer is rude to have payment in arrears to employees, and he might become bankrupt, and after his discharge, he can be the director of a company again. Can employees continue to pursue the salaries in arrears after the employer has been discharged from bankruptcy during that 6 years? And the Labor Tribunal may withhold the guarantee money or the bond from the employer. The presiding officer of the Labor Tribunal may ask the employee to pay a bond. Now, if my presumption is correct, I have reservation. I'd like to know on how many occasions have employees been withheld, have their bond withheld? Well, we have started our cross-by-cross scrutiny. Oh, I'm sorry, I was late. All right, doesn't matter. I think these questions warrant an answer from the administration. So let's pause first. This is a technical issue and is about our past record, or whether the occasions referred to Mr. Tang has arisen. So allow me to provide an answer next time because it's rather technical in nature. I don't want to answer that offhand. All right. When we have reached the relevant provisions, we will skip them, and we wait for your reply to Mr. Tang's questions before we do the cross-by-cross scrutiny. Now, I'm not asking for a CSA. Would it be better if I write a letter to seek an explanation? So you have no intention to move the provisions anyway? Yes, preliminary, that's our idea. Thank you, Mr. Tang, for your clarification. So, Mr. Tang, you're welcome to write in a letter for the administration, which will try to respond before the next meeting. Will it be after the summer recess? Yes, I think the next meeting will at least be in September. Then I have time. Mr. Lee, please go on. 79A, Mr. Allen Leung. I've read the bar's submission. I think the crux of the matter is the word closed, because the current worry is the phrase audio visual facilities has lost the closedness, so to speak, of the system. That is the crux of the matter. I'm not asking you to list audio-visual facilities under like telephone link of Section 79A. Rather, you have to include the concept that it must be something closed, not public. Can you include that? As far as I understand, closed circuit and television systems together form a kind of technology, and we say CCTV. So from this point of view, you are confined in the kind of technology you can use. When we say audiovisual facilities, the scope is wider. It will allow us to use latest technology or new technology. I think the concern of the Bar Association is security, and the legal advisor of the BC has also mentioned this point. So if we can ensure that security meets international standards, then the technology is acceptable. And as I said, we can consult the relevant committee for users of our court, and I think that we'll be able to address the concerns of the Bar Association. Yes, you'll be able to address the concerns of the Bar Association if you can ensure excellent safeguard. But I don't know how the committee of comprising users of the criminal court what will the committee do to assure us? Can you tell us the operation of the committee? I think Mr. Alan Leung is talking about a closed TV system, and the Bar Association is their concern is that it used to be a closed circuit television system. So can there be any remedy? I understand Mr. Lee is saying that CCTV is a kind of system. You cannot just take away the word closed. This point I get, but my focus is a closed circuit TV is a closed circuit, meaning that the contents the technology will not be public. For instance, if you both use a Bluetooth, then a system can be hacked. I'm discussing with you the focus of the bar's submission, and you are telling me that through the users of the Committee of the Criminal Court to ensure that in future the technology used can address the concerns of the bar about possible leaks. My problem is, while we are legislating, whether you can ensure us that the committee can play this role properly so that as legislators we can rest assured. Thank you. When we introduce new facilities, we will consider international security standards. No, my question is how you are going to put it in the law, because we are legislating. Though it may be state-of-the-art technology, but how can you ensure that before the new technology is installed, you will get the approval or support of the majority or everyone in the committee? Where can we see this legislative safeguard? Point taken. All right, what can we do in the law? We will consult the committee, and then with its consent, we will introduce new measures. We'll only introduce new measures after we've consulted and got the approval of the committee. Yes, but
asking us to make 即係而家嗰個點樣寫落去？我想問，我係咪問得個好？
I'm asking how you're going to put it in black and white in the law. Now, you can see in the marked up copy that we're going to replace CCTV with audio-visual facilities. And the Bar Association is whether we can include technical requirements in this bill or in subsidy legislation. Now, we are saying that if we put technical requirements into the law, then it will be very restrictive. Now, we have replaced TCTV with audio-visual facilities to address the Bar Association's concern. I'm saying that for criminal procedures, we have a consultative mechanism, and we intend to use that to address the Bar Association's concern. We don't want to put technical requirements into the law unless members disagree with me. I'm trying to explain to you our mechanism.
Sorry, maybe I'm not smart enough. Can you add after audio visual facilities?
或者 ought to have 或者 should have had the approval of 嗰乜乜乜 committee 咁得唔得？即係我意思係咁啊，因為你而家口頭講啫嘛。
That's what I mean. Because how can I make sure that the facilities to be installed will have the approval of that committee? I'm not asking you to write down in the law which system you're going to install, but then this users committee is supposed to be the gatekeeper. So how can you put the mechanism into the bill, or are you telling us to just trust you? Yes, we'll look at this drafting issue after the meeting. Yes, Chairman, exactly. This is a drafting issue. Now, concerning the Criminal Court Users Committee, is it a statutory committee? Was it established by statute? No, it's a committee set up by the judiciary. Then I think you need to address the members' concern. If you can't specify the technology to be used, can you state in the bill that the technology to be used must have the approval of the users committee? Is that what you want, Mr. Allen? Yes, I just want to have the assurance in the bill that the users committee can be the gatekeeper. Mr. Yu Si Wing, A1 Chairman, and also A2, I want to know the difference. A1, persons in the courtroom to see and hear persons in the other room. And then A2, persons in the other room to hear or see and hear persons in the courtroom. So, is it to see or to hear? But is it and or? I don't quite get the difference. Yes, please. Thank you, Chairman. A1. Persons in the courtroom to at the same time see and hear persons in the other room. So in other words, both. So the first requirement is the requirement in the courtroom. The second requirement is the requirement in the other room. And for the requirement in the room, it's either to hear or to see and hear. So in other words, in the courtroom, both see and hear. But then in the other room, either hear or see and hear. See and hear. So I'm of the view that concerning the Chinese version, see and hear. For 1 and 2, the English version is the same, see and hear. But then in the Chinese version, it's not exactly the same. First of all, I wish to say that this is an existing provision. This is not an amendment. And then, Chairman, concerning 2, this is about the persons in the other room. And 2 scenarios can be allowed. First, to hear persons in the courtroom. Second, to see and hear persons in the courtroom. So in fact, we haven't made any changes to this provision. See and hear. Both 1 and 2 have see and hear. So for persons in the courtroom, there can only be one scenario that is regarded as having complied with the law. That is to see and hear persons in the other room. And if persons in the courtroom can only hear persons in the other room, then that will not satisfy the requirement of live TV link. But I understand. But I want to see the difference. Why is it that for persons in the other room, they do not need to see and hear persons in the courtroom? Is that your question? So can we say see? Can we render see and hear as 看見和聽到 or 看見並聽到? In other words, using a different conjunction in the Chinese version. Yes, I understand. Now, in fact, in Chinese, the two conjunctions 和 and 並 have the same meaning. We have chosen the conjunction 並 for A2 because we think that that would be clearer. I can now understand what Mr. Yu is trying to say. Mr. Alan Leung, I don't know whether Mr. Lee is referring to the English version or the Chinese version. We look at the two versions side by side. So for the Chinese version, Mr. Yu was referring to the Chinese version. So how come Mr. Lee said he merely copied this? I was referring to the English version, Chairman. A Roman 2 original version. Persons in the other room to hear or see and hear persons in the courtroom. So in other words, in the original A2, the conjunction and is rendered 和. But then in the new version, then we have the conjunction 並 instead of the conjunction 和. And then A and B, we don't have the word and linking A and B. But how come in the Chinese version we have the word 及 meaning and linking A and B?
李先生或者律政司嘅
Mr. Lee or the DOJ?
我知道。開閉路電視喺度時，喺呢一房間一裝設過
主席，或者我哋翻。
Chairman, perhaps we can go back and check this drafting point. Please look at the whole subsection. Now, because I think you also need to look at B. You have to look at everything once. Yes. And then, Chairman, live television link. I want to say that this is my suggestion. Maybe after audio visual facilities, you can add
approved by the Criminal Court Users Committee. 我所表達嘅意思係咁樣嘅。
So that's what I'm suggesting. Mr. Lee, is that clear? Yes, please continue. 5AA. Professional qualifications of permanent magistrates. So we're looking at the professional experience required to fulfill the 5-year requirement. Can you please elaborate? Now, for a permanent magistrate, if a person wants to be appointed as a permanent magistrate, he should either be qualified to practice as a barrister, solicitor, or advocate in a court in Hong Kong or any other common law jurisdiction, and then has the required experience, and then or has been a legal officer, and so on and so forth, and then has been a special magistrate. But at the moment, the 5 years for the special service as a special magistrate. Now we are proposing that the 3 types of experience can be added together for the sake of fulfilling the 5-year requirement. At the moment, for the special magistrate post, the year of service has to be calculated separately and not together with the 2 other types of experience. So you're talking about a person who's a barrister, solicitor, or advocate in a court in Hong Kong or any other common law jurisdiction. Yes, may I refer to 1A? A person is qualified to practice as a barrister, solicitor, or advocate in a court in Hong Kong or any other common law jurisdiction having unlimited jurisdiction either in civil or criminal matters. And in fact, there is no amendment to this. So in other words, it must be a common law jurisdiction. Yes. And then 2A, 2A1 has practiced as a barrister, solicitor, or advocate in such a court. But then what about being a legal officer? I think you can look at bracket 2 below. And we have listed the various posts within the government, and experience in these posts can be counted for the calculation of the 5-year period. All right, legal officer. What about a person who has been a legal officer in a non-common law jurisdiction, for example, legal officers in the mainland? So, are they qualified under such conditions? If we want to define legal officer, we have to go back to the Legal Officers Ordinance, Cap 87. And it says that a legal officer means a person appointed to be a legal officer in Hong Kong. And then in Appendix 1, certain posts are listed, and they are regarded as relevant to the post of legal officer. So what is the definition of legal officer?
An officer lawfully performing the functions of any of the officers designated in Schedule 1 咁而喺呢個附錄1入邊咧，就住呢個譬如律政司。
And so in Schedule 1, there are posts in the DOJ regarded as fulfilling the definition of legal officer, for example, the S for J, and so on and so forth. And then there are and then Lands Department, Companies Registry, Land Registry. There are posts in these departments regarded as equivalent to the legal officer posts.
所以如果你睇返，
So if you may refer to our amendments, such as bracket 2A, Roman 3, 4, 5, we've listed, say, a post within the legal aid ordinance, and these are posts that can be counted within that period, totaling not less than 5 years. Any questions? No? Then please go on. So we've dealt with page 3, page 4, District Court Ordinance. Simply put, the amendments is, other than oral verdict, the court can can use written verdicts, and the legal advisor asked whether it should be mutually exclusive. We can confirm that the two are mutually exclusive. There won't be a mixed mode allowed. That is, for the same case, there won't be an oral verdict as well as a written verdict. You might have noted a view from the bar, and that is where appropriate, the presiding judge may hand down the verdict verbally, and he may orally set out the justifications for the verdict, but on the premise that the summary will not form part of the written verdict. Please refer to para 9 of the bar's submission. And we can confirm that this is our intention. Where the judge thinks fit, he may provide a summary verbally. But in so doing, he will expressly say that what he is going to say will not form part of the reasons for verdict. Mr. Raymond Wong, now we are now at the clause-by-clause scrutiny stage, but have some views on the policy aspects and the basis for the amendments. I think some of the points are debatable. Now, the court is allowed to give the reasons for the verdict either verbally or in writing. You claim that this will not prejudice the rights of the plaintiff or accused. I don't agree with you. While you want to save resources and to be efficient, I must say that open hearing in the criminal court is important to safeguard human rights, to ensure that the accused can have a fair and open trial. Announcing the verdict as part of the criminal procedures. In other words, we cannot agree with you. And your reply is the court will consider a number of factors. For instance, due to the complexity of the case, the complexity of the case, whether the accused is legally represented, and the language or proficiency of the accused. All these are factors to be considered, and you want to preserve the flexibility of the court. This I beg to differ. Now, how can these factors lower the flexibility of the courts? Because all these factors are relevant and important. So I think we should give consideration to the wish of the plaintiff and accused as well. Now, if one side asks that the reasons for the verdict be given orally, then the judge should do so, such as applying for leave of judicial review. Now, the rules allows the court to give a verdict on the application for leave of judicial review. But 3 bracket 3 says that if there is an application for a trial or hearing, the court must do so. So we are concerned that delivering the verdict in writing only may not be entirely appropriate, because the accused may want immediate legal advice to decide whether an appeal should be lodged. So I have digressed. But this part, amendment to District Court Ordinance, is about how the reasons for the verdict may be delivered. I beg to differ from the views of the administration as far as this is concerned. I hope that the provisions can be more concrete. In particular, factors, relevant factors to be considered by the court. Thank you. When we dealt with this issue, our thinking was, when a case is very complicated, then it would take the judge a long time to deliver the reasons for the verdict orally. This has happened, and legal representatives, the barrister, and also the accused will have to listen to the verdict that is delivered orally. And we thought perhaps the court could deliver the reasons for the verdict in writing. That is the reason for our proposed amendment, where you want to save legal costs and court resources, so on and so forth. Now, from this point of view, if it's purely from this principle, we won't object. We just say that there isn't enough certainty here. I think Mr. Wong is referring to our paper to the Secretariat, whether we can set out the relevant factors to be considered. Our explanation is each and every case is different, and our considerations cannot be exhaustive. Our list of considerations cannot be exhaustive. It would be difficult to put it down in the law. Now, if we set out some factors for a particular case, and if it is not in the case, then this may affect the flexibility available to the court. I get your point, but you talk about complex factors. How complicated, how complex can they be? We are talking about relevant factors. I don't think that is very difficult. Yes, we have another consideration subject to members' views. The court has got practice direction. Can we use practice direction to try to set out all the possible relevant factors? The practice direction can be amended very easily in a more flexible manner. So can we deal with these relevant factors using a practice direction? All right, have you ever considered this before? Well, this is the first time we have considered this. No, you are thinking about this? All right, we have these suggestions for you. You're going to amend the law, and are you going to do that? For instance, it would be acceptable if you edit in the practice direction. You have to tell us for sure whether you're going to do so. Are you going to put down all the possible relevant factors in the practice direction? Well, if members believe that it is a feasible way forward, we will consult the relevant parties first and try to include the relevant factors in a practice direction as far as possible. It will enable court users to understand factors that will be considered by the court. Chairman, this is acceptable to me if they are going to do it for sure. But my concern is usually practice direction will only be made after the bill is passed. You tell us that it may be possible for you to do that, but we are not sure. If you can give us a draft practice direction to see how the court is going to deal with the following scenarios I can think of. For instance, after a written verdict is delivered, you must give ample time for the lawyers of the prosecution and the accused to study the verdict before a trial begins. This is the concern of the bar as well. Mr. Lee. Well, if there is the consensus that this is acceptable, we will work along this line. When necessary, of course, we can give you a paper to tell us what is our intention. Chairman, we have only 3 sitting here, including you. And the chairman also mentioned the views of the Bar Association. I think this is already a consensus. So please do not beat around the bush anymore and talk about consensus. You should no longer say so. No, I'm not trying to beat around the bush. Rather, I just want to have a clear way forward so that we can proceed to the next step of work. No, I think you have to convince us that the future procedures will be fair and open. All right, I will go and consider this and give members a paper in response. But usually, practice directions are not formulated by the judiciary without any consultation. We will at least consult professional bodies such as the Bar, Law Society, and also relevant parties. There is a process for coming up with a practice direction. Mr. Yu Siwing, well, the amendment seeks to save time for both parties, and I think the initiative rests with the judge. From the plaintiff or the accused point of view, if they don't mind wasting time, they are willing to have the verdict, reasons for the verdict delivered in orally, then you have to respect the rights of the parties. So, to do it simpler, let's not talk about a practice direction. If the judge would like to give it in writing, and yet the defendant would like to have it orally, can that be done?
Yes, Chairman. Now, of course, we do take into account the wishes of the parties concerned, but then it doesn't mean that their wishes are the only factors to consider. That's why we want to put all the factors in the directions. In other words, if the verdict is to be handed down in writing, then the parties concerned must be informed as to the reasons. So it seems that your aim is to save the judge's time and not the time of the parties concerned. Is that right? Now, because it may be rather complicated if you are to come up with an exhaustive list in the practice directions. So, is it that you prefer to have things written down in the practice directions? Chairman, it's our preference to list the factors to be considered by the judge, and then leave it to the judge to work out the best arrangement. So in other words, you expect the judge to exercise this discretion. But then can the lawyers of both parties be given a chance to make or give their views or representation? Yes. Now concerning 80(6), the requirement. Why is it that there is no requirement to have the judgment uploaded onto the website? Now, because it says here that a copy of the reasons will be lodged in the High Court Library, and then a copy of the reasons will be available for public inspection in the registry of the court. But then, these arrangements are rather outdated. Most people, including lawyers, make use of the internet platform to search the judgments of court cases. Very few people will really go to the High Court Library for such information. And in fact, last time you said in reply to my question that all judgments would be available on the judiciary's website. Now, for judgments delivered by the district courts and above, we use administrative arrangements to upload the judgments onto the judiciary's website so that lawyers and members of the public can do their research or search on the internet. But then if we are to write down here an administrative arrangement, we don't think it is necessary to do so at this stage. Can I ask why? Now, at the moment, the CFA ordinance and High Court ordinance do not require that judgments be uploaded onto the judiciary's website. So, in fact, we are doing this as an administrative arrangement only. So why can't you put it down in the legislation? This is what you are doing and what you have been doing, and because the methods or the arrangements in the bill are very outdated. Now, for example, lodging a copy with the library, delivering a copy to each of the parties. Now, because we want more transparency with regard to our judicial proceedings. And the judiciary has told us many times that there is an IT plan for our courts. And our courts are moving towards high technology, more digitization. But it seems that what's written in the bill really belongs to the last century. Chairman, I think it's a matter of timing. As you have pointed out, we do want to go down the electronic route with regard to our court proceedings. And so we have to study all the laws relating to judicial proceedings and amend them at one go. And so we can amend all the relevant legislation at the same time. But we don't know when you're going to amend the district court ordinance again. In fact, there is this IT strategy, and many court users are of the view that our courts have not moved fast enough concerning use of IT. Now, I've already given my explanation, but if the chairman really wants us to take a look at this again, I will do it. But I think it's really a matter of timing and sequencing, right? But that's my view. Any members, any other views? Our legal advisor, please. Yes, Chairman. Concerning Section 80, bracket 6, there are 3 requirements. But then these requirements apply only to reasons delivered in writing. And it seems that these do not apply to reasons delivered verbally and then reduced to writing, or what? Is that right? 86 or 80 bracket 6 applies to reasons delivered in writing. As these reasons are delivered in writing, we think the arrangements ABC need to be put in place. For reasons delivered verbally, the reasons are known to all at the court hearing. And at the moment, we have administrative arrangements to deliver the reasons reduced to writing to the parties concerned, and we also have an administrative arrangement to upload the judgment onto the internet. Yes, legal advisor. Thank you very much. So there is this loophole in the law. Now, if the reasons are delivered verbally, then there is no need to lodge a copy of the reasons in the library. I understand that the judge has to reduce the reasons to writing within 21 days after the hearing or the trial. But then, is there a requirement that the reasons be a copy of the reasons be deposited in the library? At the moment, this is an administrative arrangement. So how come Section 80(6) only applies to reasons delivered in writing? Now, it's true that the reasons were delivered orally in the court, but I believe you know that for the district court rooms, they are very small, and maybe there aren't enough seats for the reporters. The reasons are delivered in the courtroom. There is no live broadcast, and if I want to jot notes in the courtroom, I have to get the approval of the judge. And say if the verbal delivery of the judgment lasts for 3 days, I don't think I can really follow all the arguments. And then, in fact, I have been a lawyer for over 10 years. And I've never gone to the registry of the court to try to find a judgment. In fact, few people in the world would do that. So please consider this issue. We'll not deal with part 5. Yes, Chair, you're correct, Chairman. We will deal with that at the next meeting. Mr. Wong? Before you arrived, we had said that concerning appealing to the CFA as of right, if the dispute amounts to or is the value of 1 million or more, they haven't completed their research. And they want us to deal with this issue later. So the papers should be available in September. All right. So I think we can move on to page 11. Page 10 of the page 10, section 12. The sum of money, whether liquidated or unliquidated, that will fall within the jurisdiction of the Labour Tribunal. I don't think this is controversial. Next one. Section 15. It's a drafting amendment. As a general power, but then under section 15(3), we're talking about the tribunal having to adjourn the hearing. Here there is reference to sections 16 and 30, but then section 30 has become a general power, and as a result, we don't think there is a need to refer to section 30 anymore, so it's just a technical amendment. All right, please continue. Nothing on page 12. And then page 13. Section 30, at the moment, is about giving security upon adjournment, but we are seeking to expand the powers of the Labour Tribunal. In other words, the tribunal can require security where appropriate. And so here it says that the tribunal may require security under various conditions or situations. Please continue. page 15. You can see that we've expanded on subsection 4. And you can see that under these conditions, the tribunal can exercise certain powers. For example, if one party tries to delay the process, or if assets, and if one party tries to dispose of certain assets, then the tribunal can exercise the powers under Section 4.
Please go on. Page 16. Registration. So we have this amendment about registration at the district court or magistrate court. Page 17. Page 17. Is it a transitional provision? Yes, it's just transitional in nature. And page 18, the first one is money whether liquidated or unliquidated, and to make it clearer. Starting from page 21, we have forms stating the year, say 19-something. This is already dated. Now we've taken this opportunity to remove references to, say, 19 this and that, and the remaining amendments are technical in nature. So, but this is about the year. We will leave the entry for year blank to make it more convenient. That's okay. And then we go to page 50. We've completed the technical amendments, and we are now on page 50. The definition of stock. Well, we are talking about securities instead of collateral. Page 51, a similar amendment. The word securities again. All right, this is about the management of deposits or management of suitors' funds. So this will make the rules formulated by the High Court safer. This will allow the court to make rules in relation to suitors' funds. Some asked how come in different courts there are different things that can be accepted. Well, in some court, cash is acceptable, in some other securities, and still others are movable property. This is about the operational needs of different courts. Of course, the High Court and our district court has a wider scope because it deals with more cases. But for small claims tribunal, because the amount is smaller, so only cash is acceptable. So this is purely from an operational point of view. Thank you. Now in High Court, District Court, and Lands Tribunal, cash, securities, and movable properties may be accepted, but when it goes to District Court, only cash is acceptable. Now, for a case where securities is involved, then in the High Court or the District Court, the securities are withheld. But when it goes to the Appeal Court, how would the securities be dealt with? Well, in District Court or High Court, they are regarded as first instance court. In a first instance court, such as the High Court or the District Court, if the judges of the view that the asset in the form of securities would be safer if they are kept by the court, well, they have this power called preservation of property. And then when there is appeal at the appeals court, the securities will still be kept by the court of first instance. It can be the High Court or the District Court. When the CFA has completed the trial and the court is confident in returning the securities to either the winning party or the losing party, then it will be handled in this way. We will not go to the suitors' funds. Now, take the High Court as example. The securities are being kept by the High Court and will stay there until the case is settled in the Appeal Court, or if the case goes to the CFA, Court of Final Appeal. When the whole case is completed, the person concerned can reclaim his property from the High Court. From this point of view, the CFA doesn't need the power to handle securities and movable properties. Now, for the same case, in the High Court, the securities were not held by the court, and if it is found in the CFA that there is such a need, then what will the CFA do? According to our understanding, this situation will not arise. The CFA is the final place for appeal, and there they will be arguing points of law. And under we cannot envisage such a scenario you referred to. We have discussed with the registrar of a CFA or the permanent judge of CFA, and it's found that there is no such need. Legal advisor, then I don't have any follow-up. But for the provisions, page 53 of the marked up copy, that's about the Lands Tribunal. 10 1AC. You say that the High Court can do something for the execution of the orders of the tribunal. And what do you mean by the execution? Are you talking about execution in general, or execution that would affect the suitors' funds? I failed to get your question. Can you please repeat? Can you please tell me which provision you're talking about? Page 53 of the marked up copy. 10AA are newly added. Suitors' funds rules. 1C. Under new section 10AA, small letter c, the execution of the orders of the tribunal. So, are you talking about execution in general, or execution that would only affect the suitor's funds. If you talk about execution in general, it is strange that it is placed here because the section is about suitor's funds. If the execution goes beyond the execution relating to suitor's funds, it's a bit strange that it is put here. Earlier on, the legal advice gave us a letter. It's related to the last question of that letter, and that is about the term execution. Should we add qualifiers to the word exhibition, just like what we do in A, B, and D? That is, we should say money, securities, and movable property. We have sought the views of the D of J. Of course, suitor's funds is a media or means for execution of such orders. If in C we add money, securities, and movable property, then we will restrict the scope of the orders, because the court can hand down different types of orders, and only a very small portion of them will involve suitor's funds. If we qualify exhibition here or orders here, then it's hard to tell whether an order can only include these three things or other things. We believe it is better to leave some flexibility here. What is your legislative intent? Will this apply to page 59, the court final appeal? Can the court of CFA rely on 10AA1C to make rules that have nothing to do with the execution of orders related to suitor's funds? No. We rely on other provisions to execute the orders of the court. This part is mainly about money. In the CFA ordinance, it is specified that rules of CFA will not be executed there. It will be executed by the High Court. So other provisions are needed for the execution of CFA's orders. So can you confirm that we should interpret this in the narrow sense that it is about execution of the orders of suitor's funds? Orders that should be executed through suitor's funds. That is, suitor's funds may be used as a means for execution of the orders, and power to execute the orders, there are separate provisions. Thank you very much. We were on page 53. What page were we on? We are done. We've completed everything. Because the remaining are related to securities. 56, 57 also securities, and 58 small claims tribunal, rules of a small claims tribunal, and then 59 court of final appeal, which the legal advisor mentioned. Okay. In other words, at the next meeting, you're going to address the issues raised at this meeting, and you'll give us information on the automatic leave of appeal of the CFA, and what else, or otherwise, whether we have case laws. Now, if there is no other issue, then the meeting is adjourned.